Are you ready to overcome the complexities and burdens that come with your success? Join the team at Centura Wealth Advisory in the Live Life Liberated podcast. Now, on to the show.
Hello and welcome to Live Life Liberated with the team from Centura Wealth Advisory. Today, Jonathan Freeman is running the show, and he's brought on a couple amazing guests who I know personally, and I'm so excited for today. We've got John and Michael Parise from Beech in studio. Well, in their own studio. They have their own studio. That tells you right there that these guys are pros. Jonathan, good morning. How are you?
Good morning, Eric. Great to hear your voice, and glad to be back here with you and both John and Michael.
Yeah, absolutely. So the big question of the day, why'd you bring John and Michael on the show today?
Well, that is a great question. So the topic of the day is buy-sell agreements. And I wanted to bring in John and Michael for a couple reasons. One, they're really knowledgeable in this space. Two, we work with them quite a bit, and I'll have them elaborate a little bit about that. And their model is quite unique, and I thought they could spend a little bit of time at the front of this describing Beech and how they serve their clients. But ultimately, I came into this both having prior experience dealing with buy-sell arrangements in partnerships, but also having done one for our own company as our partner team was looking to revamp our structure and make it more tax efficient. I now have some pretty deep insight and was excited to share both John and Michael's experience. Michael, also being an attorney, has a lot of technical expertise in this arena. And we're really just hoping to bring in some really high-level nuggets and experiences from both of them as well as us, so that our clients and those listening to the Live Life Liberated podcast can take something away and hopefully learn from it as they're setting up their small business or evaluating their partnership for the long-term benefit of all the holders. So with that, let me introduce both John and Michael, who are a father-son duo on the other side of the coast of the United States. You might be able to tell from their accent, but with that, let me say good morning, gentlemen.
Good morning, Jonathan.
Good morning, Jonathan.
And you're paying us too, right, Jonathan? Is that how this works?
It's a pro bono. So, John and Michael, probably the audience doesn't know your name or the sound of your voice, but John, maybe you can start as the founder of Beech, describing who is Beech, how you started it, and what clients you serve.
Yeah, we get that question a lot, and Jonathan, thanks for having us. We're excited about today. The Beech model, I'll keep it short, was really a model that was in a transition over the last 25 years developing. And the reason why I say that is a lot of the families that I worked with in the past were concerned about a few areas of their planning. And one was a lack of coordination amongst their current team of advisors. So I got that messaging from them. And so when I looked at my practice, I said, how do I build a practice that can help my clients collaborate with all their key advisors? So that was one insight that I found along the way. The second one was, and I ask this question often to families that I work with or we work with, who on your advisory team do you currently have that if something happened to you as the leader of the family, who's going to walk down the life cycle of your spouse and your children to give them financial advice and to protect them? And I get blank stares. So the second piece of what Beech does is that legacy of advice through the generations. So I looked at that as being another part of Beech's vision and philosophy. And the market that we serve is really attuned to that. Most of the families we work with are affluent, have privately held businesses that need to transfer generationally or to be sold somewhere along the way, and they needed a good think tank. And that's what we do here. We think through projects and opportunities for our families, and then we outsource to wonderful people like you, Jonathan, for key areas. So Beech is an outsourcing strategy, but most importantly, we act as a family CFO, if that makes sense to a lot of listeners. You know, if you look at a company structure, they have a CFO that runs the firm financially, but most families that we team up with don't have a family CFO. So we take that role and we act at that level to advise on all financial affairs. So that's the history of Beech, and it's been pretty exciting for us along the way.
That's great. And so how do you and Michael work together? Michael, you want to give a little bit about what you bring to the equation?
Well, yeah, very carefully. No, we get along great. But I was in I had graduated college way back when, and was looking sort of what I would do in the next stage of my life, and wasn't quite sure what that entailed, and decided to go back to law school because I felt that would be a way to really have a flexible degree because I wasn't sure exactly what I wanted to do. And when I was in law school, I took a lot of tax planning classes. I took a lot of estate planning and business succession classes, and knew that my father was working in the financial services arena. And so I was really interested in that whole side of the law. So I decided not to be a litigator or do trial work or things like that, and really wanted to help families focus on avoiding problems up front by doing a lot of the planning work that we now do, as opposed to trying to fix conflicts after they occur, right? So that was when I graduated. Copper Beech was being formed by my father, and so it was kind of a nice timing. So I went right into working with Copper Beech after law school, and so I really operate as the planning director.
Timing is everything in our business, right?
Yeah, absolutely. Yep.
Yeah, funny added piece to that. Michael came to me. He said, "Okay, now that I graduated law school, do I work with a law firm and get some experience, or do I work for you immediately?" So I said, "Well, here's a couple of attorneys that are good friends of mine. You can go talk to, and they'll give you advice." So they both gave me the same advice. Michael, your dad will teach you a lot more in a shorter period of time and pay you a lot more money. So it was also motivated for Michael to say, "Yeah, well, that makes sense to me." So it worked out. It's working out great.
Well, thank you both for that quick introduction and a little bit of background on Copper Beech. So, buy sells, they're near and dear to my heart. I was thinking about how we set this up, and, I kind of look at them similar, as a governance tool, like the Constitution of the United States. It's really the Constitution, or part of the operating agreement of a company. That might be a partnership of two, that might be a family-run business, or it might be multiple partners, like us, where we have succession management and trying to create a longevity plan for the structure. But when setting it up, there's a lot of considerations. There's a lot of questions that need to be answered, a lot of struggles, because ultimately we're trying to figure out those tough questions ahead of time and provide a guidebook or an orderly transition of those partner interests, despite a variety of different situations. So, Michael, since you're the attorney in the room, maybe you can give us a little bit of background on what are buy-sells and why are they important?
Sure. A buy-sell agreement, like you alluded to, Jonathan, I really like that term you used, a constitution of a business. But buy-sell agreements are typically put in place by business owners, multi-owner business owners, to really deal with how the ownership interest of that business is handled. And normally, when you think about a business, a privately held small business, the partners that are involved in that business are really doing business together. That they're very, most of the time, unique to the business. They provide a really specific role to that business, and it isn't as if somebody else could come into that role and take over quickly. So these buy-sell agreements really are designed to typically restrict the transfer of ownership to third parties. And then again, as you alluded to, really provide that orderly succession and transition of ownership. And that's really the major purpose of a buy-sell agreement.
That's great. So, what are the different, options out on the table? Obviously, most corporate or companies are formed with a corporate entity type, but there's so many different scenarios or options on the table. What do you see out there? Do you have a favorite structure, or does it really just depend on the circumstances and the goals of the family or the partnership?
Yeah, I think it really depends on the business, the type of people that are involved in the business, the type of business that we're dealing with. So you can have these agreements really work with any type of business. It can be a corporation, C corporation, S corporation. It could be an LLC or a partnership. There may be little different nuances in terms of what language is included in that buy-sell agreement, but the general principles are pretty much the same, at least in terms of restricting the transfer of ownership between them. But I know, most of our clients, when they're looking at from a flexibility standpoint, again, it really does depend on the type of business that you're in, but LLCs tend to really be probably, Dad, I think that we work with probably more of the more common ownership structure that we
Yes.
help draft these documents for, or help design, I should say.
Yeah, I know. Speaking from personal experience, we were an S corp or had multiple S corps, and as part of our restructuring, we went to both a S and an LLCs to provide a lot more options and flexibility in structuring our partnership transfer.
Yeah.
There's certainly, that's why you want to have an expert, someone such as yourself who's done it, to be able to advise and give good insight in terms of the pros and the cons, the tax benefits, and the restrictions. Many cases, various corp types have restrictions which you really need to understand what are the implications.
Mm-hmm.
Yeah, I'll jump in here for a second, and you're both correct. These documents are the guiding light of the partnership, but we take it to another level, Jonathan. Most of the time, where we start explaining to the client that not only is buy-sell agreements important to the partners, it's also important to the employees that work for the company. Because if you have an unsuccessful shareholder agreement and something happens along the way, not only do you affect the partners' lives and their families, you also can affect the people that are working for the organization. So you might have, I've seen it in the past where the company has, lost 50, 75% of their capacity because the disconnect between the partners and people's jobs were affected and actually lost their jobs because of it. So when you think through these shareholder agreements, you got to add in that there's other people involved in this agreement or could be affected by it. So I just wanted to make sure I brought that point up.
Yeah, that's a great clarification as well. So a good segue into, what are the things that we're trying to protect against when we start laying out the options and scenarios? What are what sometimes are referred to as triggering events that ultimately need to be thought through and the nuance built in? Can you maybe, Michael or John, either give us some examples of things that most people don't want to think about but ultimately need to in order to cover all the bases?
Sure. Yeah. And one thing that I think it's important to bring up as well with these agreements is very often we advise our families to really start thinking about drafting these agreements pretty much right at the outset of the business being formed. And the reason why we typically recommend that is because usually everybody's happy, everybody's excited about the business and the opportunities that can come from that. And these agreements are really, I think, best drafted when everybody's in a positive mindset, because you're going to put down things in these agreements that are going to affect every partner equally, right? So these agreements are designed to be fairly treated in terms of the partners. And so if a conflict arises, it's very difficult, as you can imagine, to probably get these documents drafted at that time. So we typically would recommend that these documents get drafted very early on in the business's formation, as quickly as you can. But Jonathan, you alluded to the triggering events. And so these are, we call them triggering events, as these are certain things that happen that will trigger the buy-sell. They'll trigger a transfer of ownership between the partners in that business. And so the most common ones are what we call perhaps our involuntary triggering events. We like to break these triggering events up into involuntary versus voluntary events. And so the most common involuntary triggering event is the death of a shareholder or a partner. So how does that event affect the business and the transfer? So that's one typically. The disability of the shareholder. There could be an accident that happens and one shareholder or partner is unable to continue working in the business. How does that transition happen? There's also things like the divorce of a shareholder and perhaps a stock or ownership interest that becomes a part of that marital settlement. Is that an event that you want to consider in your agreement? Things like bankruptcy of a shareholder. There's really a lot of these, we call them involuntary triggering events, that I think are very important to include in these agreements. We very often review buy-sell agreements that maybe handle the death or disability of a shareholder, but don't mention something like bankruptcy of a shareholder. And that could be a very important component that, again, you obviously hope that never occurs, but if it does, this agreement, as you pointed out earlier, Jonathan, acts as that constitution, that law, if you will, in terms of determining what happens then. So those are the most common triggering events that we deal with. And maybe that you can touch on maybe some of the other voluntary ones, triggering events that come up from time to time.
Yeah, I mean, when we design these agreements, Jonathan, nothing's off the table. We talk about all the key what if scenarios. That's the term I use a lot. Is it what if, one of the partners, to Michael's point, got divorced? How do we handle all that? What language in the agreement that makes a smooth transition on that particular event? There are some cases along the way where one of the partners, got involved with some drugs and caused some problems with the firm. So how do you deal with a drug issue or an alcohol issue? There's a lot of different what if scenarios that occur. And to Michael's point earlier, the sooner you address those, the better, because again, everybody's in good spirits and all these things. Well, they're never going to happen. Not with us. We're great partners or we're great friends. Well, that doesn't always happen that way. Partnerships are very difficult, projects long term for businesses. And that's why the more flexible these documents are, the more accurate they are to these events, the safer it is to act upon these documents in case there's an event. So you really have to think deeply about being honest with each other that these things could possibly happen. We need to get these in the documents. Now, when we read these documents, when we do our audits, we find that a lot of these are missing. So I would advise anybody who's listening that if you have a shareholder agreement, go back to your advisor and make sure you checked all the boxes and make sure all these positions are covered. Now, again, to Michael's point earlier, you do it now or when the business started up versus trying to change it 3, 4, 5 years down the road. Because you and I both know, Jonathan, relationships change, business structure change. And I'll give you an example. One of the questions I asked both partners in this particular case I'm referencing, I said, when you look at your document, who has an advantage of dying first or second? And I get the strangest looks. Now, what do I mean by that is when you look at shareholder agreements, let's say, Jonathan, you and I were in a partnership and the company was worth $2 million. So I own $1 million, you own $1 million of value. Well, if you and I are working on a deal that was going to have impacted the company 2-3 years from now, and I've been working on that for a couple of years, and all of a sudden I suddenly pass away. Well, that deal doesn't die, but it just added a tremendous amount of value to the company. Are you preparing your document to share that success in the future? So there's a lot of great conversations we have around these topics, and it gets everybody a little focused, but I think they're important to look
Absolutely. At. And I couldn't agree with you more. It's really devil in the details. And more often than not, I've seen that, it's things like valuation that become, and ultimately it's the money that the business is worth that drives discord or drives issues amongst partners and or the surviving individuals that would ultimately have those interests. And I just speaking from experience, knowing if it's too vague in the agreement, it just leads to more cost, more stress, and ultimately, a lot of legal bills when you're dealing with disagreements. And so the better you can flush it out, be very specific and precise, ultimately that's going to lead to a much smoother transition. But giving the topic of valuations, what are some, key considerations or key things to think about in valuing a business, especially when it's a closely held concern? There's just two partners, and ultimately, like you said, that business can dramatically change in value with just the incapacity of one of the key members.
Yeah, I think valuation is probably, other than the triggering events that we maybe touched on earlier, the valuation of the company for purposes of this buy-sell is probably the other really, really key topic that we spend a lot of time with our families and business owners on helping them design. So some of the things that you want to consider is that scenario you just mentioned, Dad. What if this event is triggered, but we have this really, really positive outlook in the future? How does that affect the valuation? And so typically putting in the agreement a very detailed valuation metric that everybody agrees upon is really, really key. And we've seen a lot of different ones. Sometimes we have seen agreements where both partners have essentially, if it's a two-partner business, to get together once a year and come up with a certificate of value, and that gets put into the corporate file. And every year, as an example, they are basically certifying together what the value of the company is. That is good or bad. Sometimes we've seen that where it's not really formally done. It's just sort of, well, I think it's worth this, and then we certify it. Well, as you can imagine, that might be perfectly fine. That might not be the best way to value it as well. So we also see things like formula clauses, right? So maybe there's an EBITDA formula that's included in that shareholder agreement or buy-sell to be able to establish the value. But that maybe is looking in the past a bit more, not looking in the future, as that scenario you mentioned, Dad. That EBITDA formula might not look at, well, what's happening in the future? Is this really a true value of the company? So that often leads many families to look at getting a formal appraisal for purposes of pegging that value for the buy-sell agreement. So that, as you can imagine, is a little bit more expensive. You have to hire a qualified appraisal to do that. And typically there's one side, the buyer and the seller are typically hiring their own valuation teams to do that. Now, there's a lot of ways you can structure it. There's no rules around it, but that's very often what we see when the business decides to go to the appraisal route is, buyer hires an appraisal to value it, seller does it on their side, and maybe we take an average between the two, or we somehow agree what the value will be based on those two different appraisals. So those are, I would say, the three principal general ways that families and business owners can really look at how to value the business for purposes of this buy-sell agreement.
Yeah, and ultimately, once you've agreed upon a value, there's that other key component, which is how is it going to get paid? And in many cases, yes, that payment structure is left a little ambiguous, or more importantly, there's structures or elements like insurance that can be put in place to minimize the impact of the business when having to pay out that value to the remaining individuals. So I know both of us deal in various levels of insurance and types of insurance, but maybe you can use a few examples of how insurance might come into play in terms of getting a well-protected and comprehensive plan in place to make sure the ongoing business isn't impacted. Sure.
Yeah. No, that's a really, really good topic to cover. And if you think about insurance as an asset class that could be used for a lot of different things in terms of facilitating this buy-sell agreement. The most common one, as you can imagine, is in that death scenario. So there's typically a policy that's owned on each of the partners in the business, and if one of the partners passes away, the death benefit is used to facilitate the buy-sell agreement. Now, what's interesting from our experience with buy-sell agreements is really the death scenario, fortunately, is really not the most likely triggering event, believe it or not. However, it tends to be the most common one that we see, and it should be. It should certainly be included in a buy-sell agreement design. But it's really interesting when you think about, well, it's probably the most unlikely event to happen. What's more likely is a partner just really doesn't get along with the other one and they want to get bought out, or one of the partners becomes disabled. And so when we look at insurance as an asset class, as I made mention earlier, how can this policy be used to also assist in those types of scenarios and triggering events as well? And so that's really where you could sometimes look at cash value life insurance as an example, that cash value can be used to facilitate that buyout. If a partner retires or a partner wants to withdraw from the business. And so there's a lot of different nuances and ways that life insurance can be designed to facilitate and to assist in the buy-sell triggering events.
Yeah, and that's a case-by-case scenario, Jonathan. I mean, every family we work with is different. So there's a lot of flexibility in designing these particular shareholder agreements with insurance funding, and that should be looked at very carefully. I'm going to just stop for a second. I want to talk about a case study that had the most impact with me, and it was a long time ago. I'm going to go backwards a little bit. If you don't have a buy-sell agreement, you should listen to this messaging. I work with two brothers. They own a company down the street from where I live. And Mark was running the company. He was operations manager, and Jim was the marketing gentleman who went out and promoted the company, did all the golf outings and all the things we see that the business owners do from a marketing standpoint. And through the years, he became an alcoholic. He had 3 DWIs. That's when you're allowed to get 3. And the 4th one he killed a little girl on a bike. God, it was terrible. It hit all the local papers, and it affected the business dramatically from that point on. And to make a long story short, the brother actually went to jail. His spouse knocked on the door, Mark's door one day, and said, "Where's my check?" And Mark said, "Well, because Jim has caused all this problem, we can't afford, we had to hire someone to replace him. We don't have extra cash flow to pay you." So she took him to court, and the judge said, "Do you have a shareholder agreement?" And he said, "No." Sent her a check because she was still 50% owner of the business. So it caused all kinds of problems by not having an agreement. And so that's why when you look at this concept or this strategy, you really have to be serious about it. Everybody should have a shareholder structure to protect everybody involved, not only the partners, but all the people that work for the firm.
Yeah, but and to add to that, if you imagine, obviously having the agreement itself is a critical component. But if that business owner that in your story, Dad, had, let's say, as an example, a life insurance policy that could have been used to help facilitate that buyout there as well, because that could have been used as a way to pay the spouse of that partner that went to jail. So again, it's really important that businesses think proactively about these decisions, and again, start them early and don't wait until there's that terrible event to start thinking about it, because by that time it's too late.
Yeah, that reminds me of another very serious topic in these designs. It's a discounted value. And what we mean by that is if someone triggers an event as a partner to another partner, let's say Michael walked in tomorrow and said, "Hey, Dad, I'm out of here. You got a week. Replace me." Well, by Michael leaving the firm, that's going to affect my business. So if I'm going to buy him out, he's causing me stress to do that. So should I pay him at a dollar for dollar value as his 50% share? The answer is no. It shouldn't be that way. That should be discounted because you're causing me to affect the business. So we've seen discounts in these agreements up to 65% of the value to a partner that causes these type of transactions that put stress on the company. So again, when you look at these agreements, we have a 4-hour conversation about these guys to really design these a specific way, but everyone's customized that we work with. A lot of these structures can be flexible in nature, but they all are very, very important to these agreements.
Totally agree. Okay, last topic, guys. So both of us are highly sensitive about tax and tax efficiency and how you structure these buyouts. Ultimately, there's a lot of decisions that you make that ultimately will impact not only the exiting partner, but the remaining partners who are left. So either of you, John or Michael, maybe you can talk a little bit about some of the considerations that you want to think about in setting up the buyout structure so that it can be most highly efficient on tax.
Yeah, that's a really, really good point. And there's 2 principal ways that these agreements can be structured, and either or will have a really big impact on taxes that you mentioned, Jonathan. So the first way is a cross-purchase agreement. And so in a cross-purchase agreement, the partners themselves as individuals are responsible for facilitating the purchase of the departing owner's interest, however that may occur. All right. So they themselves as individuals will make that purchase. The other way is an entity redemption agreement. And in that type of agreement, buy-sell, the company itself buys the stock from the departing owner, not the individual shareholders. And that could have a big impact tax-wise. And it really has a lot to do with the income tax basis of the shares to the remaining shareholders or partners in that business. So if you think about it's a simple example. If you have 2 owners of a business, they each own 50%. And let's just assume for the sake of argument, they have 0 income tax basis in their, in the company when they started it. And let's say one partner wants to retire or wants to leave the business and wants to trigger that buy-sell agreement from the and withdraw from the company. If you have a cross-purchase agreement, the second partner will be actually purchasing the value, whatever it is at that time, from the departing owner. So now if you look at that remaining shareholder's income tax basis, he now owns 100% of the company, but 50% of that company has his zero tax basis when he started, and the other 50% has his basis in those shares is whatever the purchase price was at the time the buy-sell was triggered. Okay. So if he then turned around to sell the interest in the business, he's going to have a much better income tax result from that transaction because half of the value has an elevated income tax basis. Okay. You have to follow the bouncing ball here a little bit. It's a bit complicated, but you have to you have to contrast that with the entity redemption agreement, which is in that scenario, the business is really going to be buying the shares. So when partner 1 departs, partner 2 now owns 100% of the business, but his income tax basis does not change. It's still zero, but he owns 100% of the company. Okay, so if he then, again, in our example, went to sell the business, he's going to have a zero basis on 100% of that value. So again, this is really some of the considerations that we help our families and business owners with in considering to design these agreements, because that can have a really, really big impact long term.
So you really need some good tax advisors along the way here. So you have to work very closely with your team to make sure all these tax views are discussed and make sure everybody understands them and the impact it has for the partners on the exit.
Yeah, can't agree with you more there, John. So, well, that was actually very enlightening, and maybe Eric, you can help close us out here. I thought it was both enlightening for myself and hopefully for the audience as well. And just touching the surface on some of those key issues that all partners that are trying to run and maintain their business long term need to think about as part of their organizational docs.
Yeah, absolutely. The nice thing is that both John and Michael, especially you in this scenario, you have a way of explaining these things that really breaks it down. It leads to a lot of other questions, but it's much more clear for the entire audience. So I appreciate everything that you and John have brought to the table today. And Jonathan, of course, thank you for bringing them on as special guests on your podcast.
Oh, my pleasure. And you might want to give them a quick little punchline for their own podcast, which I often listen to and find extremely informative as well. The Truth About Wealth. Isn't that correct, gentlemen?
Yes.
Yeah. Mm-hmm. Yep. That's a lot of fun to do. We enjoy these.
Yeah, absolutely. And you guys have done a ton of episodes. I mean, what episode are you guys on anyway?
45, I think.
I think so. It's into the 40s.
Yeah. And they're just absolutely packed with all sorts of good information. And I mean, who couldn't sit and listen to you guys all day anyway? I mean, it's fantastic.
My wife.
Okay, fair enough. I think we can all agree with that one. My wife as well. She's like, "Oh,
she goes that again."
She doesn't listen to this podcast, right?
Exactly. No, she doesn't.
She's not going to listen to this one. That's for sure. All right, gentlemen, thank you so much for your time today. It was a pleasure listening to all of you just talk about this stuff. Absolutely.
Thank you, Jonathan.
Thanks, Jonathan. Always a pleasure, my friend.
This is great.
Have a great day, guys.
And of course, the last thank you goes to you, the listening audience. Thank you for tuning in and listening to the Live Life Liberated podcast with the team from Centura Wealth Advisory. If you have not subscribed to the podcast yet, please click the subscribe now button below. This way, when they come out with a new podcast, it'll show up directly on your listening device. This makes it much easier to share these podcasts with your friends and family. Again, thank you so much for listening today. For everyone at Centura Wealth Advisory, this is Eric Johnson reminding you to live your best day every day. And we'll see you next time.
Thank you for listening to the Live Life Liberated podcast. Click the subscribe button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Centura Wealth Advisory. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning. Centura Wealth Advisory. Centura is an SEC-registered investment advisor with its principal place of business in San Diego, California. Centura and its representatives are in compliance with the current registration and notice filing requirements imposed on SEC-registered investment advisors, in which Centura maintains clients. Centura may only transact business in those states in which it is notice filed or qualifies for an exemption or exclusion from notice filing requirements. Past performance is no guarantee of future results. Tax relief varies based on client circumstances, and all clients do not achieve the same results.